Welcome to LexTalks Legal Topics Simplified, where we break down legal topics and try to make them a little easier to understand.
Sounds good.
So today we are diving deep into enforcement of foreign awards procedure and essentials under the Geneva Convention.
Wow, that's quite a mouthful.
It is,
Yeah.
but it's a fascinating area, especially for all of you aspiring legal eagles out there.
Absolutely. In our globalized world, disputes often cross borders, and figuring out how to actually enforce these arbitral awards across different legal systems, it's pretty important.
It's really important. And so let's paint a picture for everyone.
Okay.
Imagine you have two companies, one in India, one in Australia. They have a dispute. They decide to go to arbitration. But instead of doing it in either of their countries, they decide to go to London.
Okay.
So now you have arbitrators in London. They issue a decision. So that's your foreign arbitral award.
Right.
But then what if one of the parties just decides to ignore it?
That is when things get interesting, and that's where this Geneva Convention comes in. It's basically an international agreement that lays out the rules for how countries recognize and enforce these foreign arbitral awards.
So it's like a safety net to make sure these awards actually have some teeth and can't be ignored.
Precisely.
Oh. So before we get into all the little details of the Geneva Convention,
Yeah.
There's one thing that I think always trips people up, even in law school. I know it tripped me up.
Okay.
And that's this idea of recognition versus enforcement.
Yeah, these terms are often used interchangeably, but they actually have different meanings.
Yeah, so recognition versus enforcement. What's the deal?
It's actually pretty simple. Think of recognition as acknowledging that the award is legitimate.
Yeah.
Like saying, hey, we see this foreign award and we accept that it's valid.
Okay.
Enforcement, on the other hand, that's about taking action to make sure that that award is actually implemented.
I see.
It's about making the losing party actually comply with what the arbitrators have decided.
So recognition is passive, enforcement is active?
Exactly. And for a little historical context, the Supreme Court of India clarified this back in 1993.
Yeah.
They said that enforcement automatically means recognition, but not the other way around. You can't enforce an award if you don't recognize it in the first place.
That makes sense.
Right.
So we've got our foreign award. We know the difference between recognition and enforcement.
Okay.
So let's bring in this Geneva Convention.
Right.
But hold on a second. Isn't this a pretty old agreement?
Um,
I mean, does it still even matter today?
well, it's true, the Geneva Convention that goes all the way back to 1927,
Wow.
but it's still relevant, especially when the newer New York Convention doesn't apply to a specific case.
Okay, so it's not totally irrelevant. It's like a good backup.
It's a tool in your legal arsenal.
All right, so how does this all play out in India?
Okay.
Did they just adopt the Geneva Convention wholesale, or did they kind of put their own twist on things?
Well, they had a pretty clever approach. They integrated the main principles of the Geneva Convention into their own Arbitration and Conciliation Act of 1996.
Oh, so it's not a direct copy and paste, but the ideas are there in Indian law.
Exactly.
So let's say I'm representing a client, and they need to enforce a Geneva Convention award in India. Where do I even start?
Okay, well, first, you need to know which court to go to.
Right, of course.
In India, the high courts are the designated places for these enforcement applications.
So not the lower courts, not the Supreme Court, straight to the High Court.
Right.
Okay, so I'm standing in front of the judge, award in hand. What are the key things I need to prove to get this thing enforced under the Geneva Convention?
There are three crucial elements you need to show. First, you have to show that the award is based on a valid agreement that falls under the 1923 Geneva Protocol on Arbitration clauses.
So the foundation of the whole thing needs to be solid.
Exact.
You can't build a house on sand, as they say.
Right.
What's the next hurdle?
The second thing is that you have to prove both parties to the dispute are from what we call reciprocating territories.
Okay, now there's some legalese for you.
I know, right?
Reciprocating territories? What does that even mean?
It basically means that the countries involved have agreed to recognize and enforce each other's arbitral awards. It's like a two-way street, a legal handshake between countries.
It's like a club of countries that have agreed to play by the same rules.
Exactly, and that's where things can get tricky because the Geneva Convention only applies if both countries are part of this club.
So if one of them's not a member, no Geneva Convention.
Right, that's
Yeah.
one reason why the newer New York Convention is more popular because it has a much wider reach.
Interesting. But let's stick with Geneva for now.
Okay.
So we've got the valid agreement and the reciprocating territories. What's the third piece of the puzzle?
The third requirement is that the award itself has to have been issued in one of these recognized reciprocating territories.
It's like a chain of trust, making sure the award comes from a legitimate source.
You got it.
Okay, so I've got all that. What paperwork do I actually need? What documents are essential for enforcing a Geneva Convention award?
Okay, well, first, you obviously need the original award, or at least a certified copy.
This makes sense. Can't just show up empty-handed.
All right, you need proof.
What else?
You'll need to show that the award is final and binding.
Meaning no more appeals, nothing.
Exactly. It's the end of the line.
Okay, final piece of the puzzle.
You need to show the arbitration agreement itself was valid under the applicable law.
So everything above board from the beginning.
Exactly.
So we've got the award, the proof it's final, and the evidence of a valid agreement. Are we good to go?
Well, not so fast. Even with all of that, a court can still refuse to enforce the award.
What? There are loopholes, even after all that. This is getting interesting. Tell me more about these grounds for refusal.
Okay, so for instance, if the award was annulled in the country where it was originally issued,
Oh, so it was final, but then something happened?
right, that can be a problem. Or let's say one of the parties wasn't properly notified about the arbitration.
That seems fair. You can't hold someone to a decision they didn't know about.
Exactly. And then there's this catch-all provision where a court can refuse enforcement if Indian law says that dispute couldn't have been arbitrated in the first place.
So some disputes are just off limits for arbitration, no matter what.
Right. Certain matters are just non-arbitrable under Indian law, and the courts will uphold that.
Okay, so it's like a final check, making sure the Geneva Convention doesn't overstep its bounds.
Exactly.
Wow, we've covered a lot of ground already. I think this is a good place to take a breather.
Yeah.
We'll dive into some fascinating cases and more of the ins and outs of the Geneva Convention when we come back.
Sounds good.
Stay tuned for part 2.
All right. So as we were saying before, you can have a really strong case for enforcing a foreign award under the Geneva Convention.
Right.
But there can still be some bumps in the road.
I see.
And one of those is this idea of public policy.
Ah, yes.
Ah.
The infamous public policy exception always seemed a bit vague to me. How does that actually work when it comes to enforcing these foreign awards?
Well, under the Geneva Convention, countries can actually refuse to enforce an award if they think it goes against their own public policy.
Okay.
The tricky part is that what public policy means, that can be different from one country to another.
Oh, I see. So what's fine in one place might be totally unacceptable somewhere else.
Exactly. And this can make things really unpredictable.
It's like trying to hit a moving target.
Right. It would be nice if there were some clear international rules about what exactly violates public policy.
Right.
But for now, it often comes down to how a judge interprets it.
So let's get out of the theoretical and into some actual cases.
Okay.
Real-world examples are always the best way to understand these complex ideas. You mentioned earlier that there are some interesting cases that show how these Geneva Convention principles actually play out.
Absolutely. One that comes to mind is the Set oil case from 1960.
Okay.
It was a dispute between an Indian company and a foreign company. They went to arbitration. The Indian company won, but then the foreign company refused to pay.
Oh, so the Indian company had to go to court to try to enforce the award?
Exactly. And they tried to do it under the Geneva Convention.
Seems straightforward enough. Did it work?
Well, it wasn't quite that simple. The Setse oil case ended up being a landmark ruling
Okay.
because it showed how important it is to follow all the rules of Section 57 of the Arbitration and Conciliation Act, which is the part that deals with enforcing foreign awards.
Okay.
The court said that the burden of proof is on the party trying to enforce the award.
Yeah.
You can't just demand enforcement, you have to prove your case.
So you need to have all your ducks in a row, all the paperwork, everything needs to be perfect.
Exactly. The Setse oil case showed everyone that enforcing a foreign award isn't just a rubber stamp. It's a serious process, and you need to be thorough.
Makes sense. It keeps things fair and makes sure the system works properly.
Right.
Are there any other cases that can help us understand the Geneva Convention better?
Another interesting one is the 1963 Società Anonima Lucchese Willy E. Vini Luca case,
Okay.
also in India.
Right.
This one was a bit unusual. Well, there was this Italian company that had a contract with an Indian company to sell wine.
Wine, okay.
The contract had an arbitration clause, and of course a dispute came up, so they went to arbitration. The Italian company won, but when they tried to enforce the award in India, they hit a snag.
What happened? Did they miss a deadline or something?
No, it was the contract itself.
What was wrong with it?
The court said it was actually illegal under Indian law.
Oh.
And here's the interesting part. The court said that even though the arbitration was valid and the award was properly issued, the fact that the original contract was illegal, well, That made the whole thing unenforceable.
Wow, so even if you win, you can still lose if the original contract was bad.
Exactly. The Societa Anonima Lucchese Culii Vini Luca case showed that everything needs to be legal and above board right from the start.
The contract, the arbitration agreement, everything.
If the foundation is shaky, the whole thing can collapse.
That's a good way to put it.
Yeah.
So we've been talking about the Geneva Convention, but you mentioned there's a newer treaty, the New York Convention. How does the Geneva Convention compare to that?
Well, the Geneva Convention was really important in getting this whole idea of international arbitration going.
Okay.
But it's true that the New York Convention is what most people use today. One big advantage is that it covers way more countries. Over 160 countries have signed on.
So it's like a much bigger club than the reciprocating territories we talked about.
Exactly, and that makes it easier to enforce awards across borders.
I see.
The New York Convention also makes the whole process smoother. It lays out very specific reasons why a country can refuse to enforce an award.
So less room for countries to just block awards they don't like.
Right, it's all about making things more predictable.
So it sounds like the New York Convention is definitely an improvement.
It is, and that's why it's become the go-to treaty for international arbitration.
But does that mean the Geneva Convention is completely useless?
Not necessarily. There are still some situations where it might apply, especially if one of the countries isn't part of the New York Convention.
So it's good to have it as a backup.
Exactly. In international arbitration, you never know what kind of situation you might encounter.
Now, going back to that reciprocating territories requirement under the Geneva Convention,
Yeah.
it seems like that could be a big problem for businesses that work all over the world.
It is something to think about.
So what should businesses keep in mind?
Well, they need to be strategic when choosing a place for arbitration. If they think they might need to enforce an award in a certain country, they need to make sure both their country and that other country are part of the Geneva Convention and that they recognize each other.
So it's not just about picking a neutral place. You have to think about the big picture.
Exactly. And that's where a good lawyer can really help.
How so?
They can advise businesses on the best strategies for choosing a place for arbitration that will make it easier to enforce the award later.
So having an expert on your side is crucial.
It can make all the difference.
I see. So choosing the right place for arbitration, that's a big decision.
Absolutely. And it's just one example of how the Geneva Convention can really affect business decisions.
Well, we've covered a lot of ground in this part. We've looked at some interesting cases, talked about the pros and cons of the Geneva Convention, and even how it affects businesses. But before we move on to our last segment, I have a question that I think will be especially helpful for our law students listening.
Okay.
We've been talking about enforcing foreign awards in India.
Right.
But what if it's the other way around? What if an Indian company wins an arbitration award in another country?
Okay.
What do they need to do to enforce that award back in India?
That's a great question, and it comes up all the time. The process is basically the same, whether the party trying to enforce the award is Indian or foreign.
So no special treatment.
Right. They still have to go to the right high court file, all the necessary documents, and meet all the requirements of the Geneva Convention.
So everyone's on a level playing field.
Exactly. The Indian legal system aims to be fair and impartial, and that applies to enforcing foreign awards, too.
So Indian companies can feel confident about going to international arbitration, knowing that they have a fair shot at enforcing their rights if they win.
Exactly. And that's really important for building trust and encouraging international trade.
I agree. Well, I think we've done a great job covering the Geneva Convention in this part. We've gone over the main points, looked at some interesting cases, and talked about how it all affects businesses. But we're not done yet.
Right.
In our final segment, we'll answer some of the most frequently asked questions about this area of law and give some practical tips for our aspiring legal eagles out there.
Sounds good.
And we are back for the final part of our deep dives into the Geneva Convention and all the ins and outs of enforcing foreign arbitral awards.
All right, let's wrap things up.
We've gone through a lot, from the basics to the big picture stuff. Now, I want to focus on some of those common questions that pop up.
Sounds good. Let's tackle them.
All right, so here's one that often trips people up. Can a party challenge a foreign award because it's patently illegal?
That's a tricky one. Patent illegality. It's a well-established reason to set aside a domestic award in India. But when it comes to foreign awards under the Geneva Convention or the Arbitration and Conciliation Act, it's not explicitly mentioned.
So where does that leave us?
Yeah.
Can it be used or not?
It's not a simple yes or no. While Patent illegality might not be a direct ground to challenge enforcement. It doesn't mean you have no options.
Okay.
Remember the public policy exception we talked about earlier?
Yeah.
That's where this argument could come in.
So you could say that enforcing a patently illegal award goes against India's public policy.
Exactly. And courts have actually used this reasoning in several cases. They've said that enforcing an award that totally contradicts Indian law, well, that would go against public policy.
So it's not about the award itself, it's about the bigger picture.
Right. It's about saying that enforcing it would hurt the Indian legal system.
I see. So moving on to something more practical.
Okay.
What about stamping and registration? Does a foreign award need to be stamped and registered in India before it can be enforced?
Thankfully, no foreign awards don't need to go through that process.
Well, that's good to know. But I thought stamping and registration were mandatory for pretty much all legal documents in India.
They are for a lot of documents, but the Supreme Court has said foreign awards are an exception. There are a bunch of judgments that confirm this, including the 2018 case MS Shrine EPC Limited v. Rio Glass Solar.
Okay, so one less thing to worry about. Now, here's something that often confuses people, especially law students. What's the main difference between a foreign judgment and a foreign arbitral award?
That's a really important distinction. A foreign judgment is issued by a foreign court. It's the decision of a judge or a panel of judges.
Okay, so it's part of the regular court system.
Right. A foreign arbitral award, on the other hand, comes from an arbitration. It's the decision of a neutral third party or panel of arbitrators chosen by the parties to settle the dispute outside of court.
So it's more private and both sides agree to it.
Exactly. And that makes a big difference in how they're enforced in India. Foreign arbitral awards are under the Arbitration and Conciliation Act, and foreign judgments have their own rules in the Code of Civil Procedure.
Got it. Different procedures for different things. Now, before we wrap up, I have a question for our student listeners. What advice would you give to aspiring legal professionals who are interested in a career in international arbitration?
Well, international arbitration, it's a really interesting field, and it's growing fast. There are lots of paths you can take. My first piece of advice, immerse yourself in the subject matter.
So beyond just regular classes, what should students focus on?
Learn about the major international treaties and conventions that govern arbitration. The New York Convention is key, and of course the Geneva Convention, even though it's older, it's still relevant sometimes.
Okay, so those are the building blocks. What else?
Keep up with the latest case law, both in India and around the world. Things are always changing, so knowing the recent decisions and trends, that's a big advantage.
Good advice.
What else?
Get some practical experience. Internships with law firms that specialize in international arbitration, moot court competitions, even research projects. All of those can help you connect what you learn in class with the real world.
So hands-on experience is key. Absolutely. And never stop learning. This field is always changing. There's always something new to learn. Go to conferences, read legal journals, talk to people working in the field. Keep your mind active and keep learning.
Great advice. Always be curious.
Yeah.
Well, I think we've covered the Geneva Convention pretty thoroughly. We've looked at the key parts, analyzed some important cases, and even talked about some practical tips for those of you starting your legal careers.
We've covered a lot of ground.
And to our listeners who are still with us, thank you for sticking around and learning with us. There's so much to explore in the legal world. Keep learning and keep asking questions.
I agree. The more you learn, the better prepared you'll be to handle any legal challenge, whether it's here in India or across international borders.
Thanks for listening to LexTalks. Subscribe and join us again for another deep dive into a different legal landscape.